The Bombay High Court today dismissed Vodafone's plea in the transfer pricing case. The court asked the British telco to approach a lower court first to file its objections. Now, Vodafone had challenged the IT department's move to add 8,500 crore rupees to its taxable income over transfer of shares within the group. Let's straight away go across to Ashwin Mohan, who's joining us with all the details. Ashwin, you were right there at the courtroom today. What does this really mean? Does it really mean a setback for Vodafone, or the very fact that it can go to a lower court is still an option open for it?
Well, Nisha, this is yet another fresh setback as far as British telecom giant Vodafone's legal fortunes in India are concerned. What has essentially happened is that the Bombay High Court has repeated what it did a year back in the case of Hindalco. Hindalco was also facing a similar transfer pricing order. It directly went and approached the Bombay High Court, and the Bombay High Court told Hindalco to go back and explore alternate remedies. That's exactly what it has told Vodafone today. And remember, the stakes are really high. The Income Tax Department wanted to add 8,500 crore rupees to the taxable income of Vodafone in India. Vodafone wanted to avoid the lower forums because they were of the opinion that the lower forums like the Income Tax Appellate Tribunal do not have the power or the scope to cover international transactions. But that argument was shot down by the Bombay High Court. So essentially what the High Court has done is that it has directed Vodafone to explore alternate remedies. What are the alternate remedies? At lower forums you have the Income Tax Appellate Tribunal. Now, as far as the jurisdiction is concerned, the big setback for Vodafone is that the Bombay High Court has also given discretionary powers to the tax department, because it has said that the tax department has the power to pick out international transactions and scrutinize them suo moto. So that is where the bad news is for Vodafone. But there is a silver lining for them too. The order has been stayed for a period of 12 weeks. Within this 12 weeks, if they agree by it, they can go to the ITAT. If they don't agree by it, they can of course go and challenge this order at the Supreme Court. And of course, let's also hear out some tax experts who have been speaking about the ramifications of this order on ET Now.
The High Court in its wisdom felt that all alternate remedies that are available under the income tax law should be exhausted, and it's only thereafter that the matter can come to the High Court. So I don't think that the High Court seems to have gone into the merits of the case. It has merely dismissed the writ petition, saying that there is an alternate remedy that's there available in the law and that needs to be exhausted first.